5 speakers here, and the first one is Joana REBELO MORAIS, Institute of Social Sciences, University of Lisbon, a limitation of political rights, the case of the first democratic election in the Portugal 1975. And she is a PhD student of comparative politics at the Institute of Social Sciences, Lisbon, University of Lisbon, with a particular scholarship founded by the Portuguese Foundation for Science and Technology. She holds an MA degree in political sciences. Her master thesis, the I'm really sorry, I would say, the Commission of the Black Book and the Fascist Regime is in search of the truth. Received an honorary mention in the 19th edition of the foundation, prestigious foundation. So her research interests include democratization, founding elections, and true commissions. Okay, Joanna, go ahead. 12 minutes.
Okay.
Okay.
I'll try to respect that. Also, because we're all tired, and I don't want to bore you to death, so I'll be quick. And maybe I'm going to. Well, okay, this is fine. Sorry. Okay, so. Today I bring you the case of the limitation of political rights in Portugal. This is a very specific case, and I will start by telling you what theoretical framework I'm trying to get to. Since this is really an ongoing work, this is part of my PhD thesis. So I'm trying to look at the limitation of political rights in Portugal as a lustration mechanism. So as you all must know, lustration is a type of transitional justice mechanism that's common in transitions by rupture or collapse, in the case of Portugal, by rupture. The aim of the lustration mechanism is to remove individuals associated with the former regime from relevant positions either on the military or governments, or to prevent them from regaining access to power. This specific form, the limitation of political rights, it's not very explored in the literature of transitional justice, and not specifically as a lustration mechanism. I argue that this makes sense because there's not a lot of consensus in the transitional justice literature, but the mechanisms are well established, and to that we all agree on. So for me, I look at limitation of political rights, since they were a way to prevent the access from the wrongdoers of the dictatorship as a lustration mechanism. My aim, since this is part of my PhD thesis, again, an ongoing work, is to contribute to the broader debate about the impact of these measures on democratic consolidation. As far as human rights, we can look at this question from two opposite angles. First, because we are talking about transitional justice, we are talking about doing justice to the victims and to punish the wrongdoers. In this sense, it makes sense to look at this question. But if you look at the other way, if we are establishing a democracy, we want the elections to be free and universal. Does it make sense to prevent someone from voting, which is the most elementary way of political participation? We are talking, as we will see, we are talking about a measure that encompassed 48 years of dictatorship and a lot of institutions. So, is it fair to assume that anyone who worked in the state apparatus during the dictatorship necessarily related to the regime, or accepted, or corroborated? For me, no. I strongly believe no. But we will talk a little bit more about this ongoing. So, very brief presentation about the Portuguese case. On April 25, 1974, after 48 years of dictatorship, there was a revolution, a military coup d'etat, and Portugal initiated the third wave of democratization in the modern world. It's a very specific case since it was military but non-violent. Very few people died, and it was by accident, actually. There was some shootings near the political police headquarters, so it was not the military who killed anyone. And this military coup was actually a result of the disruption of the military hierarchy, because the ones who did the revolution were the captains, not the ones above them. One other aspect that makes this coup very different than others is the fact that the military stayed in power during almost a decade, as democratically as possible in the context. And also, the revolution was supported by a highly mobilized civil society. The Portuguese people went to the streets when the coup happened. And it's considered one of the reasons for its success. In terms of transitional justice, it was an extremely punitive process, since all kinds of mechanisms of transitional justice were put in place, from trials to a truth commission. That's another one of my research, favorite research topics. Every kind of mechanism, illustrations, trials, truth commission, also memory, also financial compensation for victims. The first free, democratic, and fair elections in Portugal were the elections for the Constituent Assembly, exactly 1 year after the coup. And they were, and they still are, and I think that this is going to stay this way forever. They were the most participated electoral act in the history of the country, with a participation of almost 92%. Presently, it's around 60%, so I think this is going to stay this way, and this is going to be the most participated electoral act in history, in the history of Portugal. So, the law, I'm sorry, the decree law that established the limitation of political rights had an history and was born in a specific way. In May, the first provisional government, and we had a lot of provisional governments in the very few months after the revolution, the first provisional government nominated a commission, and the commission that was composed by specialists in law that drafted a proposal of what the electoral law would be. And this specific limitation of political rights is included in the electoral law. So the commission was composed by 7 jurists. They were linked to the main political parties, although some of them were actually a part of these parties, others were just associated. Each one of these jurists was assigned the topic and prepared proposals. Then the 7 of them discussed, adopted, voted, and approved by unanimity or majority these proposals. So, the civic incapacities, which is another way to call the limitation of political rights, were a controversial topic in the Commission and were approved, but only by majority. And in the basis of this decision of approval was the fact that the Commission or the members of the Commission considered that it would be a serious injustice to the thousands of victims of the fascist regime and to the people in general to allow the persecutors to exercise alongside the persecuted their democratic right to vote. In August, so 2 months and a half later, the project of the electoral law was delivered to the second provisional government. So 2 months, second government. By November, the third provisional government approved the electoral law. And this electoral law was divided by 3 decree laws, which are laws approved by governments, as you all know, and the one that contemplated the limitation of political rights, either passive and active, meaning you couldn't vote, but you also couldn't be elected, were contemplated in the Decree Law 621B/74. So, this law comprised 26 institutions from the dictatorship, like the presidency, the government, the National Assembly, the armed forces, the courts, the political police, or the censorship, and different positions in each of these institutions. To be precise, 71 job positions inside every one of these institutions. And the law ranged from May 28, 1926, which was the beginning of the dictatorship in Portugal, to April 25, 1974, which is the date of the revolution. So again, we are talking about 48 years of dictatorship, 26 institutions, 71 job positions. I still don't know how many people precisely were impossibilitated of voting and being elected. I still don't know, but that's one of my objectives. I estimate maybe 100 people. This decree law could be divided in 3 parts. So the ones who could not vote, which were 63 job positions in 24 institutions, and the ones who could not run. So they were the same, 53 positions, plus 18 and 2 more institutions, meaning the people whose passive electoral capacity was withdrawal was superior to the active voting capacity. But there were also some exemptions, and they were also contemplated on the law. They were excluded of the limitation of political rights, the ones that were nominated by the military for public or political positions after the revolution, so the ones that the military saw fit to start the democracy were exempted from this law, and the ones who went to court to request their exemption. They just had to prove to have shown repudiation for the authoritarian regime before the revolution, and their past actions didn't represent effective support for the regime, which was what I was referring in the beginning, because working for the dictatorship doesn't necessarily have to mean that you support the dictatorship. So this was the 2 things that people who went to court to ask for the exemption had to prove. Very important when you think about the limitation of political rights in Portugal were the process of the first democratic election that ever took place. And the process of voter registration was especially relevant. In 73, 1 year before the revolution, there were only 1.8 million registered voters. And specialists from this time period say that this number couldn't be trusted. And the proof is that when a new voter registration began on December 9, 1974, a few months after the revolution, there were 6.2 million. So, in fact, these numbers couldn't be trusted. But then again, the elections in the dictatorship were not fair or universal or free, so it made sense that there were only 1.8 million voters. It was also during the voter registration process, I'm having trouble with this word, I'm sorry, but it was also during this process that this decree materialized. So those who were affected by the limitation of political rights were excluded from these lists. I'm going to hurry very much. There were only 2 complaints about this after the election, so 2 official complaints about people who shouldn't have voted or in this case, who shouldn't have been in the list of the parties that got there somehow. I don't know how this was addressed for now. I can also say very quickly that this law was, after the election of the Constituent Assembly, was included in the new constitution, although I don't know the expression in English, but this was some of those measures that go in the constitution but then dilute over time and disappear. That's the case of this. In Portuguese it's transitório, in English I really don't know, I'm sorry. So the limitation of political rights was only valid for the bodies that were invested during the first legislature. And it was eliminated in 1982. So, to conclude very quickly, by now what I want to do, because again, ongoing work, is to assess the role and interests of political parties, because I think it's very important, and what they tell me is that they didn't have anything to do with this, and I can't believe it, so I have to search about this. I also want to evaluate the impact of the limitation in the composition of the parties' lists, and if there were possible repercussions on the limitation of the configuration of the Constituent Assembly, and therefore in the constitution that resulted from this assembly. And again, I want to estimate the number of people affected, and all your suggestions are very well needed, so thank you.
Thank you very much. Our next speaker is my colleague from the Jesuit University, Ignatianum, Dr. Agnieszka GRZECHYNKA. She's a lecturer at the Institute of Political and Administrative Sciences. And also she's the owner of public relations agency GoPublic, and long-time journalist in Poland, member of the Polish Society, Political Societies, Sciences Society, and the other society, Polish Society for International Relations, expert in public relations, journalism, and her special interest is the Catalonia relationship between Catalonia and Spain. Dr. GRZECHYNKA, please go ahead. 12 minutes, I will show you. Okay, thank you.
Thank you for this comprehensive introduction, and thank you for listening to me. It's a pleasure. I would like to start with maybe not introduction, but initial information for you, because I'm sure that as we meet here, we know a lot about Catalonia. People who are from Spain know a lot about these tensions about Catalonia and Spain. But when I started doing my research on Catalonia, in Poland, the knowledge about Catalonia was very weak. Everybody knew FC Barcelona, they knew Gaudi, Costa Brava, but they didn't know that identity issues are so strong in the region that they can lead to independence. And by the way, this is me investigating in Catalonia. Many people in Poland also knew the difference between this classic Spain, as we know it. I know it's not looking like this all the time, of course, and Catalonia, which was, of course, different. But the knowledge wasn't, as I said, very deep. Once again, for all of you who are from Spain, this will be trivia, so I'm sorry for this, but we have people from different countries, and we will have in other lectures about Catalonia, so maybe this introduction is necessary. Catalonia is a very big region and has over 7.5 million inhabitants. It's the largest regional payer and has its own institutional system. There are not so many regions in Europe who have such privilege to have their own institutional system being a region. It was all possible thanks to the Constitution of Spain, which not only created parliamentary monarchy, but also regional state system, which enabled for 17 regions and 2 autonomous cities coexisting. But all those regions are very different from each other. Of course, this is no surprise that Spain is a multicultural country, which is great and has so many advantages. We have languages, different music, different traditions, even cuisine, and it's amazing. But diversity, as we know it, can also cause problems sometimes, especially when one of those cultures thinks that their people have something more in common than just traditions or language, that they belong to a different nation. When we have people who think that they belong to a different nation, it can lead to separatism. And this is exactly what we see in Catalonia, and this is exactly what led to the famous or infamous referendum from 1st October 2017. And this leads us to the first initial question. Are Catalan nationalism and independence, separatism, a new phenomena? Of course not. We have seen this from the very beginning when we look at it from the historical point of view. Crown of Aragon, when Catalonia was existing as Catalonia. Later, Guerra dels Segadors is very brief summary, so because we don't have much time for going into details. Repressions under Philip V, which were felt very deeply in Catalonia, and finally Renaissance from 19th century, when not only Catalan culture revives, but also political life, leading to the creation of political Catalanism, federalism, and later in the 20th century, 2 declarations of independence, and finally repressions under Francisco Franco's regime, which were fought by Catalans. So, answering the initial question, those nationalist aspirations are not something new. It's not something created by current politicians who just had the idea of separating from Spain. But this all leads us to the first human rights dilemma. Was denying the Catalans the right to vote, to organize this referendum, a violation of human rights? And I'm answering this question knowing, and we all know this right now, that this idea was not new. Was this violation of human rights then? According to the Constitution of Spain and according to Spanish internal law, it was the violation. It was illegal because the Constitution states very, very clearly that there is indissoluble unity of the Spanish nation and there is no possibility of any region to separate from Spain. Point. But Catalans, wanting to organize this referendum, brought up another argument, human rights. They said that the right of nations to self-determination is the first of the human rights, and it is confirmed by many convents and the Charter of the United Nations. But, as you may ask right now, it is the privilege of nations. So, are Catalans a nation? I see reactions in the room, and I'm very thankful for that. According to definitions that are commonly used in science, in political science, we could say they are a nation because they are ethnic, economic, political, social, cultural community created in the historical process, manifested in conscience of its members. So we could say they are. But of course, according to Spanish Constitution, they are not. The Spanish Constitution mentions only one Spanish nation and nationalities. And it was confirmed by Spanish Constitutional Court in 2010 when there was discussion about new autonomous statute of Catalonia, and self-recognition as a nation was the most affected area and was said it was unconstitutional. So Catalans formally are not a nation. But even if they are not a nation, even if this referendum was illegal, this leads us to another human rights dilemma. Was using force against voters a violation of human rights, even if this referendum was illegal? According to Human Rights Watch, according to United Nations, it was a violation of human rights. All the reports that I have gathered indicate that many things went wrong and that they shouldn't be carried out this way. But human rights dilemmas don't end here. We have the third one. Considering the arrests made during and after the voting. And it's the question. I'm not talking about statements. These are questions and dilemmas. Are the Catalans, do we have Catalan political prisoners in Spain? It's another question. According to media, yes, we do. But as I was a journalist, I have to admit that when media say something, it doesn't mean it's true. So, but according to the media, there is an issue of political prisoners. But according to law, there may be an issue of a violation of human rights, especially because we have this amendment to the Penal Code from 2005, which decriminalized participation in a referendum, even deemed illegal. So the question is still to be decided by the court whether these arrests were legal and whether those arrested have to be punished. Final question. Why is Europe raising concerns about human rights in regard to Spanish-Catalan relations? Why are we asking those questions? Why am I investigating it being Polish? Well, it's not because we fight for Catalan independence. It's not. It's because we have so many regions in Europe that are closely watching what's happening in Catalonia. And what will happen eventually will have a huge impact. This is just a sneak peek of what I've been doing researching online. If you look at Belgium, for example, Greece, Italy, Germany, or even Russia, you see that people are interested in what is happening in Catalonia. They are looking for those information online, and it will definitely have its impact. When I was planning to research Catalonia in terms of human rights, and I said I'm coming to this symposium, my colleagues said, you know, leave it. Curiosity killed the cat. But I believe that curiosity actually is something that drives us as scientists and leads to fruitful discussions which are unable to be carried out by politicians. It's the place to talk about those issues, and I hope it will be a beginning of very interesting discussion later. Thank you very much, and gracias por su atención.
Thank you very much. It was exactly on time, and we will right now ask for the locals to a certain extent. I mean the Spanish colleagues, professors. Professor Carlos Fernandez LIESA is from Carlos III University of Madrid, Human Rights and Democracy, Europe, Spain, and Catalonia. He is a full professor of international law and international relations, director of the Department of International and Ecclesiastical Law and Philosophy of Law here at the university, and he was the director of the Instituto de Estudios Internacionales y Europeos Francisco de Vitoria. He is the director of the journal Revista Electrónica Iberoamérica and Tempo de Paz. Sorry for my Spanish, I would say. He is Institute Bartolomé de las Casas. He directed different research projects. So he directly joined, I would say, with Gregorio Pessis Barbara and other people, and was a coordinator of the international law part of the certain book, I would say, the common book. He directed already more than 20 collective works. Professor, I am impressed. I would say, please take a floor. Go ahead.
Thank you very much for your presentation. And I was born in Aragon, no? Catalonia always formed part of Aragon, no? Since 9 centuries ago, no? At least, and never was an independent kingdom, no? Or republic. Well, my democracy and human rights are in a good situation in Spain. Nonetheless, there are some problems derived from economic, political, social, and systemic crisis. The impoverishment of middle class has brought about an increase in xenophobic racist attitudes. Furthermore, the globalization and the state weakness have contributed to a growth of nationalist phenomenon. In Spain, the growth of extremist parties like Vox show a reaction of Spanish nationalism against separatist nationalism. The growth of ethnic nationalism is not only a Spanish problem, but a general phenomenon in other parts of the world, in poor and in rich countries, in Europe, Africa, and Asia, and America, less in my view. In the past, nationalism was disaccredited. After the Second World War, people rely on plural democracy and human rights as a solution. The citizenship notion was attached to the Constitution independently of the culture, language, or people origin. Cultural pluralism and diversity is a value, not homogenization and pure society. To be a Spaniard is possible when you are from different regions, part of Spain, or even languages. There are not only one cultural identity, and values are not the same as identity. The Spanish, Basque, Catalan, Aragonian, Andaluces people are plural, not ethnic-centered. Now, in past 5-6 years, we are witnessing a social fractioning in Catalonia. Population is divided by ethnic and cultural questions. It is not a question of democracy, but on tribalism. Population is divided in two sides, two Catalonias, or part, and is fostering the dialectic enemy. This social fragmentation has some tribal and ethnical features. This is an important problem for the situation of human rights in Catalonia. On both sides, one is more dominant from the point of view of political, economic, and social force, and that is the Catalan nationalist side. The pluralism is in risk for the nationalism. The nationalist hegemony is very strong. Non-nationalist people are in non-dominant situation. Some specialists did research on the consequences from the perspective of human rights. First of all, there has been a spiral of silence. The anemic position of separatism is a lot better than the rest of population. There is a fear to be excluded from the community if you are not secessionist or nationalist. If you are not separatist, you cannot progress in political and social position. There are a lot of problems deriving from that. The main problem of human rights in Catalonia and in Spain, apart from poverty, are closely related to nationalism and populism. The nationalist power in Spain, Catalonia, and Basque Country has built this situation after 14 years in control of the media, education, political institution, and society. They use propaganda in a magistral manner. They create symbols, a language, and a story that is a fake, but has penetrated in society. The fight for freedom is now in Catalonia on the side of non-nationalist people. They do not control media, universities, budget, institutions. They are excluded and they need us. Non-nationalist people are in non-dominant position. To transform this situation is very difficult because they continue to control power. The fight for human rights are in Catalonia. The challenge is to transform this situation. To create a new state is not the solution. Catalan people have not the right to freedom, determination. Is your presentation? It is not an occupied, oppressed, or a colony. It is part of Spanish people from immemorial time. The Kingdom of Spain is a state and a nation. At the same time, nationalists deny that Spain is a nation. And doing so, they attack the pluralism and diversity. Last decades, regional government has built a nation, excluding the others, nation building, with the goal to obtain an homogeneous Catalonia. This brings into mind quasi-ethnocide politics. The new generation cannot learn their mother tongue at school, because in fact it is not bilingual. The rule of law is broken because they don't comply with the judgment of Constitutional Court, Supreme Court, nor High Court of Catalonia. The control of Spanish government is theoretical, but in practice is void. In that real situation, children are discriminated. According to PISA report, Spanish speakers in Catalonia adolescents have a 10% less average score in all the examinations, except in math. This is a proof that linguistic immersion is not only against Spanish bilingual model, but also produce indirect discrimination, or direct even, in a great part of people in Catalonia. More than a half are their mother tongue, Castellan or Spanish. Spanish speakers in Catalonia have an inferior socio-economic level. Politically, they are not dominant, even though they are the majority, but they are a glass ceiling. It's necessary to contribute to the transformation of this. Some very famous cases as Quebec and Scotland cannot be followed in Spain, in my view. Quebec, Scotland, and Catalonia share that they are born in democratic states as a consequence of nationalism. But Canada and Quebec are very different from Spain and Catalonia from the historical, social, and constitutional point of view. The principles applicable are very different. In Quebec, federalism, democracy, and legality principle. In Spain, our constitutional principles are better. Equality, pluralism, solidarity, and unity, legality and democracy too. The human rights values are closer to Spain than in Canadian system. We have to be very cautious toward constitutional migration that sometimes are a template or a sophism. The Scottish model is for another reason not applicable to Spain. And we shouldn't forget that sometimes voting is more disastrous, like in Brexit. We cannot vote on taxes or death penalty in singular cases. Catalonia is a rich region, because from centuries ago, a lot of Spanish investment and state subsidies, support and policies have been put into Catalonia. Catalonia is not an aggrieved region, but a beneficed region. The abandoned part of Spain is in the center, not in the Mediterranean coast. Internal migration was produced from center to the coast. Spain state helped Catalonia as the best network of transport with Europe, the rest of Europe, like Basque Country. In Aragon or Navarra, border areas with France do not have a communication network with the rest of the world, nor with Europe. Because of that, most people migrate. It's the same in Castilla, Teruel, Extremadura, Galicia, and other parts of Spain. Spanish unity is furthermore a question of solidarity, that is, of human rights. In Europe, only rich regions want to secede. They don't want to keep the solidarity to other regions. And equality is the result of solidarity. European Union is not a social state. It's a market with some policies. All solidarity in the world depends on the state. To defend unity is to defend solidarity. Pluralism is another value to take into account. Spain is a plural nation. That is a nation with diversity, cultural, linguistic, ethnic, but at the same time with unity, derived from a long historical background, from constitution, and from a consensus. The fight for power by regional elites are the real problem. This is not a question of human rights. The elites use people to be more powerful. To change this situation is necessary to take into account that Spain has a full democracy. International rankings on democracy, rule of law, and human rights show that Spain has a first-level democracy. There is an international campaign against the reputation of Spain. They compare Spain to countries like Turkey, Azerbaijan. These types of comparison are xenophobic and remind one the black legend built when Spain was an empire since the 16th century. From that moment, there are negative stereotypes against Spain. For example, the Times, in a leading article, editorial, with the title Inquisition, described the Catalan situation, but the content was completely different from the title. These stereotypes are common. It's the result of secessionist propaganda, not combated by the Spanish government. Thank you very much.
Thank you.
Thank you very much, Professor. An immediate reaction by Professor Helena MATEU, Universidad de Barcelona. The floor is yours.
Thank you very much, Professor TORROJA, MATEU.
TORROJA, I am sorry.
No, it's because in Spanish.
I didn't say because I didn't know how to pronounce it. I was afraid slightly.
Thank you very much. Thank you very much for your time. I'm a Catalan. I'm very happy to be here. I'm very happy to see that people from Poland, as Agnieszka, is interested in Catalonia. I want to start that I feel very close to my Catalan citizens, as well as to the Aragonese, the Madrid, or the country, Basque country, or the Andalusia. We have the same values, we have the common history. So I feel really a deep Catalan. My parents, grandparents, all my history are from Catalan. And I feel Spanish, and I feel European, and I feel a citizen of the world. I'm really a cosmopolitan person. Before starting, just two very small, it has never been before last year, a Catalan declaration of independence from Spain, never before. In 1931 and 1934, there were declarations of independence of a Catalan state within a Spanish federal state. So never before, there are no precedents. And also something very important that from Poland or other European countries is not. They are not taking attention. It's about the violations of human rights in terms of discrimination that Catalan people are suffering from Catalan government. People who doesn't speak Catalan, or people who they are not separatists, they are suffering violations of human rights. This is very important. I will tell you more about this. So I'm going to talk about human rights and self-determination of people, which is the relationship with secession, which is the difference. It's very complicated and long topic. I will try to summarize it in 4 main statements. I would say some words about the norm of self-determination. Second, I will talk about the biased reinterpretation of the norm, what is behind it. And third, I will answer the question if minorities or any part of a state are a people in the sense of the norm. And fourth, we will see if minorities or a part of a state have a right to the so-called remedial secession. And I will finish, if I have the time, with some conclusions. First, about the international norm of self-determination. This is a fundamental right of self-determination of people, and it's a fundamental principle of public international norms, a jus cogens or peremptory norm. These norms are accepted and recognized by the international community as a whole and can only be modified or derogated by another peremptory norm. They uphold general values of the international community. No dispositive norm can contradict them, nor may any state or group of states act or legislate against them. There are very few parentory or jus cogens norms, very few. Like all fundamental principles of public international law, the right of self-determination of peoples is also a customary norm. In other words, it is a tacit norm adopted by states by consensus and manifested in state practice and opinio juris. This is the belief that this practice is required by law. This opinio juris is on display in two famous resolutions of the General Assembly: the Declaration of Granting of Independence to Colonial Countries and Peoples, Resolution of 1514 of 1960s, and the Declaration on Principles of International Law of the General Assembly Resolution 2625 of 1970. This opinio juris can likewise be found in certain treaties, such as Common Article 1 of the two human rights covenants of 1966, the Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. Although this text offers some information about the norm, they do not provide an exhaustive description. To identify the content of a customary norm, it is also necessary to look at the state practice, not only to these resolutions and treaty. With regard to the relationship between the resolutions and the treaty, in international law, norms can be formulated in several sources of law at once. There is no hierarchy of sources in international law, but rather a hierarchy of norms. So, Article 1 of the two covenants can construct the jus cogens norm in a more or less concrete way, but it cannot contradict its essential norm, its essential content. Well, the norm of self-determination of people had the purpose very clear to grant a right to accede to independence to those colonies that had yet not to attain it. As Professor Miaja de la Muela says, the adoption of this norm was revolutionary in history. And it was possible because of the contemporaneous driving forces as the conference in Bandung in 1955. The promotion of respect for human rights and fundamental freedoms was mainly founded on the abolition of colonialism and other forms of exploitation and subjugation of people, such as the military occupation of people as in Palestine, or the apartheid system in the South Africa. When the International Court of Justice had to interpret this peremptory customary norm, it has referred to the aforementioned resolutions, and in one case to Common Article 1 of the Covenants. It has unequivocally concluded that the jus cogens content of the norm was a right to accede to sovereignty and independence, where applicable, attributed only to colonial and occupied peoples, nothing more. I go to the second part of my presentation, the biased reinterpretation of the right to self-determination. What is behind this reinterpretation? This, what I call the fallacy of this reinterpretation. Well, the reason of this reinterpretation is mainly because there is no international norm expressly granting a right to separation from the territorial state to a part of its people. The Supreme Court of Canada in 1988 was very clear on it. Should a state such as Canada or the UK wish to grant a right to secede or to separate politically or constitutionally. That is a matter of internal concern. International law respects the sovereignty of all states. How each one is territorially organized is at the discretion of the state itself. At the same time, the principle of territorial integrity is an inherent right of the state, not a duty. Since secessionist movements do not have an internal right to secede, they have to invoke the right to self-determination of colonial peoples. And to this end, they have used two strategies based on the fact that the text and the wording of the resolutions and the treaties is somewhat vague. The key lies in how one interprets the norm. Not all interpretations are valid. There are general secondary rules governing interpretation in international law. I'm not going to focus on it because of the time, but we can discuss about this. My third point. First strategy of secessionist movement. They say that they are a people in the sense of the norm. They say that they are a nation or a people. Well, this is not so important. Why? Because the positive norm, as established in the resolutions and the treaties, clearly wards the attribution of the right to accede to independence, the external self-determination, to the colonial people. I'm not going to read now the wording, but this is very clear. That's right that both resolution and common Article 1 also do include a paragraph providing that, and I read, all people have the right freely to determine without external interference their political status and to pursue their economic, social, and cultural development. Well, this paragraph concerns the right to internal self-determination, not to external self-determination. This inclusion was due to the USSR government at that moment. We can discuss on it. The question is that the internal right to self-determination includes a right to political independence and territorial integrity. The USSR was very interested in including this right to territorial integrity. And it's clear that the subjects of this right to internal self-determination were the people of the states as a whole. So the peoples of the states as a whole have a human rights to decide their internal self-determination. It's a human of the whole peoples of the state. The interpretation rules leave little room for other interpretation of these points. We can discuss it in greater detail. To what extent can we include minorities or a nation or the Catalan people or country Basque in the meaning of the people in this norm of external self-determination? Well, hardly or not at all. Minorities, nations, were excluded from the list of subjects of the right. States expressly granted the rights to people of colonial territories and not to minorities nor to nationalities. The territories were expressly considered as a whole, delimited by the colonial, 1 minute? Okay. By the colonial principle of uti possidetis juris, not by their color, race, or religion. People were treated as an accessory of the colonial territory. So the norm established by the states was very clear. The states did not wish to introduce the international law, the political Wilsonian criteria of one people, one state, or one nation, one state. Not at all. The states didn't want to include this. The jus cogens norm has not changed. The end of the Cold War and all the facts we saw in Czechoslovakia, the breakup of Yugoslavia, the dissolution of the USSR, the facts don't change the law. I can finish my presentation, the 4 points. We can talk about the remedial secession on the debate. Just to conclude, only 3 ideas. It is not true that contemporary positive international law, the lex lata, attributes a right to separation to a part of the population of a state due to the principle of self-determination of people. Not true at all. Second, nor can secessionist movement allege the exercise of self-determination as a political value founded on a moral norm, because not such value exists, because the value of internal self-determination of a state's entire population was legally protected, while the value of the external self-determination of part of the population was denied. There is not such political value to allege. And third, if the independence movement of Catalan, of country Basque, they wishes to embrace the revolution that a secession is, they can do it. But it will be better to base its claims on its desire and the social force behind it. This attitude will be more honest and reasonable than asserting the lie of a legal or moral argument that does not hold up. Thank you very much.
Yes. Thank you very much. Thank you very much. Our last speaker is Professor Carlos Pascual Blanchuelo, Complutense University. He is holding for a referendum to decide on the succession of the territory in accordance with international law, the effects of recognition of states. Professor, go ahead.
Oscar, please. Is not here my presentation? No. No, I have. Okay, it's not necessary. It's okay. Okay, I can do it without the presentation. Don't worry. Okay. Okay. First of all, I want to thank the scientific committee for accepting my paper, to giving me the opportunity to explain my ideas about this issue, and also to share with another colleague my point of view in a research about the effects of recognition of effects and the legality or illegality of referendum to decide on the secession, separation, succession in international law. The title of my paper is the holding of a referendum to decide on the secession of a territory in accordance with international law, the effects of recognition of a state. So I'm going to focus in 2 points, if I have time to do it. First of all is legality or illegality of referendum to decide the secession of a territory. And the second point is to emphasize the importance of the institutional recognition of states in international law, that I think that we can explore in this institution in order to go in depth with us. But furthermore, my paper is a consequence of a personal reflection. I was wondering many times, why Scottish, why Quebecois, why Bosnians have been able to vote in a referendum to decide the new war of a new country, and why Catalans are not able to do it. Is Spanish democracy less democratic than I thought? This is my reflection in order to do this. And also I was wondering, but all peoples in the world has the right to decide in a referendum to succeed, to be separated from another country, from the state. And even inside Catalonia, the people for the provinces of Catalonia, Tarragona, Lleida, Girona, have the right to decide if they want to keep inside Catalonia. So what is the limit of this right to decide? No, these questions were in my mind. First of all, I realized that in recent history, many referenda to decide on the secession, separation, succession, it's not the same. Afterward, we try to speak a little bit about it, have been held referendum to decide on this secession. For example, in Ivory Coast, Togo, Bosnia, Herzegovina, Scotland, Quebec, Latvia, Lithuania. But my conclusion, my final conclusion was that the legality or illegality of a referendum is an internal affair. It depends on the domestic legal framework. So it's a very easy answer for Spain. As in the Spanish Constitution, referendum for regions are prohibited. Regions are not allowed to hold referendum to decide the separation from the state. And if you want to approve the referendum for regions, you have to reform the Constitution. It's rule of law, okay? So this is the point. But after that, as an internationalist as I am, or I try to be, I turn to international law. And international law, I wonder, does international law say about this referendum, or the secessions, or successions, or separations? And first of all, on the one hand, I have to analyze the principle of territorial integrity. That is very important, essential principle of international contemporary international law, sorry. Article 2 of UN Charter, United Nations General Assembly Resolutions 1514 and 2625. On the other hand, we have the principle of the right, the jus cogens rule, that is the right to self-determination that teacher Helena TORROJA has explained better than I'm going to do. But it's found in many others international treaties. But there is a clash between these two principles. In my opinion, there's not a clash. It's not only my opinion, it's the majority of the doctrine, no? But Resolution 2625, and it's very important to read it, frame the right to self-determination within the decolonization process. It's not open to every people in the world. It's framed to colonial people. It's a right for colonial people. After that, I decided to analyze the International Court of Justice advisory opinion about the Declaration of Independence in Kosovo. And the question requested by Serbia to the International Court of Justice was, is the unilateral declaration of independence by the Provisional Institution of Self-Government of Kosovo in accordance with international law? And it's very similar to the title I put for my paper, no? Because I wanted to find similarities. But unfortunately, this judgment missed a great opportunity to clarify this point in international law. Gave an escape answer because the court stated, international law did not grant, did not forbid the declarations of independence because this is an internal affair. So this confirmed my previous theory, but it's not a good answer for international law to know, to clarify this point. But however, this resolution helped me to focus my research. On the one hand, I couldn't understand why the court said that, because contrary to the court judgment, I understood that international law does approve some successions, some secessions, some separations from the state. No? For example, directly, it approved succession for colonial people. That professor, teacher Helena TORROJA has explained it. Secondly, and indirectly, in my opinion, I think that also international law accept and approve separation by agreement or secession by agreement. And how does the international law do that? In my opinion, international law do that with the institution of recognition of a state that afterwards I'm going to explain a little bit better. Thirdly, indirectly, I think also that international law, with clauses and limits, accepts and approves the secession as a remedy in case of massive violation of human rights for the minority, for a people inside a state, or, for example, people marginalized or oppressed people. In these cases, with clauses, and we'll see several cases, also by the recognition of a state, sometimes international law, or maybe the states in the international community, approve or accept this process. As a consequence, international law also accepts and recognizes the referenda held in these successions and separation. This is the link between the referenda and the Declaration of Independence. But international law has never supported a general right of secession outside these specific cases, unless if the referenda are contrary to national or international law. The second point to remark in of the International Court of Justice advisory opinion on Kosovo was the following statement. International law was limited to examine the international legal effects or consequences that could derive from a given set of existing political facts. Therefore, I understood that one of the most important things that the resolution wanted to remark is the importance of the recognition of states. I said before 2 cases in which I think the recognition of states is very important in order to create a new state in the international community, but also I think that the International Court of Justice was saying that to us, was telling us, okay, the most important thing for international law are the effects of this declaration. And the effects receive an answer from the international community. Let's see afterwards. Okay, so the importance of recognition of a state. As you know, international law say that all aspiring candidates to a statehood has to comply with 3 requirements: territory, population, and effective government. And also the doctrine added one more, is legality criteria, that the independence has to be in accordance with national, and international law. With the highest respect, I don't agree with the reduction to 2 effects of the classical institution of recognition of states. Some authors advocate for the declaratory effect of recognition of a state. For them, the state pre-exists to the recognition if the candidate fulfills with the aforementioned requirements. On the contrary, other authors consider that recognition of states has a constitutive effect. For them, the new state cannot exist without the recognition of other states. In my humble opinion, the recognition of states is a more dynamic institution. It's not merely declaratory, merely constitutive effect. In my opinion, it's more complex effect and relative effects depending on the case. I am going to use a case-by-case analysis in order to show my proposal of the several effects of the recognition for the creation of new states in the international community. First case, Czechoslovakia. It was a case of separation. 2 states, in an agreed manner, decided to separate, to dissolve the state. In that case, in my opinion, the recognition of the rest of the international community has had a merely declaratory effect, a mainly declaratory effect. Declaratory because the state pre-existed to the recognition of the rest. But it's not the same in the following cases. Second case, the breakup of the USSR and the former Yugoslavia. In my opinion, in these cases, we cannot generalize. It's not very easy to include all the cases. But mainly, the recognition of the rest of the states in the international community were essential for the survival of these new states. And the recognition was majoritarian, unanimously, for the majority of the international community. In my opinion, the effect for recognition in this case was mainly constitutive. Okay? Third case, more complex. I don't know how is time, but more complex.
1.5 minutes.
Oh my God. The case.
I was waiting for 30 seconds.
Okay, the case of Kosovo. In the case of Kosovo, I think that, as you know, after the Declaration of Independence, some states, leading by the US, the United States of America, France, and the UK, recognized Kosovo as an independent state. Until today, 112 countries recognize Kosovo. But on the other hand, there are many other important countries in the world that didn't recognize, that haven't recognized Kosovo as an independent state. 81. No, yes, 81, sorry. So for some countries, for some states, the recognition tried to promote, to support the newborn of the new state. But for the other state, they are trying to prevent the creation of the new state. So in these cases, for me, recognition has, on the one hand, a potentially constitutive effect, and on the other hand, a partial dismissive effect. Okay? So I say partial because this opposition didn't prevent it, because Kosovo exists like an independent state, limited because it cannot join the European Union, the UN, etc. I'm going to go faster. Abkhazia is similar to the case of Kosovo, but contrary. And I think that the massive opposition of the international community had the effect of substantially dismissive. And that's why Abkhazia is not a state. Has only 6 recognitions in international community. But finally, we have the case of one political entity aspiring to become, to gain a statehood, but that it couldn't manage any recognition in the international community that is the case of Catalonia. The non-recognition of the majority of the international community has have the effect of the impossibility to become a new independent state.
Thank you very much, Professor Consuelo. I mean,
So I want to ask a question. What has happened if, for example, the United States hadn't recognized Catalonia after the Unilateral Declaration of Independence in 2017? I let the point there, but I have more points to speak. Sorry.
I know nothing about the political human rights, but we have an expert here, Professor Davis, and I mean, he's going to run the second part of our panel, and it will be up to him, I would say. But each of you will have 4 minutes if he will ask the questions.
Okay,
I would say
thank you.
Yeah. According to the timetable, we have to finish 7:45.
Okay, I'll be quick. So I'm going to use first names because we're all friends, or more likely because I'll be less likely to mispronounce your last names. If I mispronounce your first names, please correct me. So I'll go in order of the presentations, starting with Joana. This idea of the Portuguese transition. So one question, considering where we're sitting, is what lessons can Spain learn from Portugal's transition? I see the United States transition after the Civil War and slavery and oppression as being an utter failure. Spain's transition in the 70s has been pretty less than robust. And so what can we learn from Portugal? What can Colombia learn from Portugal? Can we compare the embrace of including the opposition, including all the parties in democracy in countries like Colombia with the Portuguese experience or with other countries that had used lustration? And then lastly for you, is there any measurement of the legitimacy of democracy, short-term and long-term, when lustration has taken place? Okay. Also, take a look at the Venice Commission has given guidelines based on the European Principles of Human Rights on lustration, and the new European Court of Human Rights case, it's the Garajano case. Okay, so the Catalonia scholars, all of you. So I'm also the curious one who might have their cat killed, so forgive me if I make any glaring errors here. But so this one, to what extent, if any at all, is the Catalonian problem caused by or made worse by Spain's lack of a robust transitional justice process after Franco? Maybe nothing, maybe something, I don't know. I know in the United States, our lack of transitional justice after the Civil War has caused many of us progressives to want the South to secede again, but I'm not sure if there's a similar relationship here in Spain. So, Agnieszka, is criminalizing the vote for independence a violation of human right to speech, to free speech, as an act of protest? Is making the vote in Spain, the act of voting for independence, a crime, a violation of the human right to free speech, to free expression? If I were their lawyers, that's what I would. Yeah, understand. You could, what's the argument that it's not? Maybe it's to justify the
possibility to vote.
Yeah. So the act of voting for Catalonian independence was not valid to secure independence, but was it a valid act of political speech?
Political, okay.
Yeah, and therefore, is it a violation? Because if it's a violation of the European Convention to criminalize the vote, then the vote is legal, and I think it adds some legitimacy to it.
You are making my responsibility very, I would say, complex and complicated from this sense. So that, okay, one question, second question for three Spanish colleagues, and the one question for the Polish.
Okay,
separate.
so
3 minutes each.
I will
Okay.
answer the easy ones, okay? I answer only the
Don't feel like you have to.
They're very
There's
good
thoughts, right?
questions, very good questions.
Things to research going on. You don't have to answer them. Okay, so Carlos. So if Catalan nationalism and anti-pluralism are driving Catalonian independence, how do we empower anti-independence majority without feeding Spanish nationalism and anti-pluralism? Make sense?
Can you repeat it?
Yeah, so if you say that Catalan nationalism and anti-pluralism are the dominant forces feeding Catalan independence, how do we promote Spanish unity without feeding Spanish nationalism and Spanish anti-pluralism? Vox.
Thank you very much.
I have one more. Okay, I'll
This is going to take whole time.
No,
I would say.
Okay, do
Give
Muslims?
a chance, I would say, to those.
What's the
We're not
political?
going
Only
to-
one.
Give it time before dinner. We give it time.
We have time. We
The,
have time.
the last question is, what's the political solution to the Catalan problem?
Great.
It's a question
Yeah,
to
I
me.
left the big one for
Okay,
you.
thank you.
Okay, thank you very much. So 3 minutes each, I would say. We start from
Very brief.
No, for me there's no question.
No, you?
We start with our Portuguese colleague. Go ahead,
Okay,
3
thank
minutes.
you. So thank you for your questions. Since I don't have a lot of time, I'm going to answer to the easy ones only, because I don't have a lot of time to think about this. About lessons, well, the Portuguese case was a transition by rupture. The Spanish case was a negotiated transition. And in terms of transitional justice, this limits what can be done. So if there are lessons to be learned, maybe in terms of memorialization, not in terms of trials or truth commissions, because in my opinion it's late, especially for a truth commission, since it's what I know best. But I think it would also be nice to leave it up to the Spanish people to decide if these kind of measurements make sense or not. As I said, in Portugal we had all kinds of transitional justice mechanisms, not in Spain, because the type of transition doesn't allow it. As far as Colombia, I think Colombia can take some lessons from other countries in Latin America, where they were good process of transitional justice, including good truth commissions, the Argentinian one, for example. So I don't know. I think a lot of lessons can be learned from Portugal, but let's keep it this way. As far as the parties, actually, what the limitation of political rights did, but not only, was to completely exclude parties that could identify with, let's say, authoritarianism. In political science, we don't call the Portuguese dictatorship fascist, although the Portuguese people call it, and the victims and the opposition, but in political science it's not correct, because it was not a fascist regime. It didn't have the characteristics that had to be called this way. But actually, the possibility of parties identifying with this ideology, or far-right parties, it was completely annulled by the limitation of political rights, in my opinion, and also by the constitution, because in the Portuguese constitution forbids any party with fascist ideology. So people that were more to the right could maybe integrated themselves in maybe our center democratic social party. But that's one of the elements I'm trying to figure out. I don't have a conclusive answer to this. And I'm done.
Okay, thank you very much. And Dr. GRZECHYNKA.
Thank you very much for your question. I will use my 3 minutes to the full, but just a few seconds to answer to your remarks. Thank you for that interpretation of history. I'd be happy to talk about it, because you know it from the first hand, but I believe you can't say there weren't declarations of independence, because there were declarations of independence.
Not from the state of Spain. The declaration
of course.
Within.
Of course, we can discuss what were the terms of those declarations, the conditions, whether they entered into force or not. But there were some form of declaration of independence. You had third declaration of independence in 2017. It didn't enter into force because it wasn't recognized by other countries. But it was again a declaration of independence. But I'd be happy to talk to you.
Yes.
Answering your question, even if we assume that voting was legal, even if we can't, I believe we can't accept the conclusion of the voting because any democratic terms haven't been met during the voting. Many people didn't participate because there were campaigns of encouraging and discouraging people to vote. It was so confusing that people didn't know if it will be legal or not, so many decided not to go to cast their vote. We have seen people being prevented from voting in many places, ballot boxes being carried out through the window, voting cards missing. So the votes that were counted weren't corresponding to any legal terms that should be met during such vote. So even if we assumed that the voting should be legal, it wasn't. And we can't say that people voted pro-independence. It hasn't been decided.
I was asking if it criminalizing, putting people in jail for organizing.
Mm-hmm. It's for courts to decide. I'm just a politologist. I'm not a judge, so it's not for me to decide. I'm just raising questions because people in Poland and other places in Europe are seeing this and asking the same question. What's happening? Is it legal? We have so many questions about human rights being asked everywhere in Europe, including Poland. And we're okay with that because this is the place, such conferences, to discuss such issues. We're not politicians. I'm not making any political statement right now. And I'm definitely not being in favor or against Catalan independence. I'm raising questions. And I'll be happy to answer any if you have. Thank you.
Oh, so your time is gone.
It's gone.
Okay, thank you very much. Professor LIESA.
I don't want to speak because the difference of view are so great that I prefer silence. No, in Spain we follow the same solution that United States Supreme Court in Alaska or in Texas. No, you can read Supreme Court, even you critic a lot. But you critic, but it's obligatory to follow those kind of solutions. No? The law is important to be followed by all people, all citizens. No? In Catalonia, there has been a coup d'etat and a great attack on democracy. The European Commission has Timmermans, has made a lot of declaration in that sense, Then the values, the European values of democracy, or human rights, legality, are broken there, not by Spanish government, by regional government. Then, in my view, it's not a political problem. Maybe it's a political problem, but the solution not is political between regional golpistas and the rest of the country, The solution is the Constitution, and the European Union Treaty and the Spanish constitutional values, because in Spain we have a consensus between nationalist Spain that is silent. From that constitution is dead, and separatist nationalist. Then, in that moment, to continue with that consensus is better for all extremists. Vox, you speak about Vox, but Vox has not power. Never. Vox is born by separatists. Then separatists has a lot of power, no? They can give a lot of money for seminars, for experts, for academicians, and that is the question for journalists, for politicians, in my view, to stop an attack to a democracy like Spain. Spain is a democracy, a full democracy. Even better positioned than the United States or other countries, like Poland, in all international rankings. And then we have to defend this democracy against a coup d'etat.
Okay, thank you very much. Professor TORROJA MATEU.
Yes, to me cross. Well, very interesting question, Jeffrey. The first one, you have talked about to what extent is the Catalan problem linked to the transitional justice and linked to Franco. Well, this is just the question. Is represents to me how the secessionist movement has won the information struggle, because they have they have make people in other countries to think that we are still a Franco's regime. Not at all. We, in 1978, we adopted the Spanish Constitution, the present one, based on the values of human rights, democracy, the principle of legality. We are a rule of law state. We belong to the European Union, we belong to the Council of Europe. So please, we are not in a transitional justice system. No, not at all. All the power is in Catalonia, in Galicia, all the power. Spain is a very decentralized state. It's like a federal state. There are no power. Really, this is probably this is our problem. The power is in Catalonia. It's not a central state. So please, we are a rule of law state and a democratic state. This is very important. It's not the Catalan problem based on this. Completely, I assure you. Secondly, against the question of if the criminalization of the human rights to freedom of speech and the 1st of October. Well, against this is the struggle of the secessionists. They have won this information. Democracy is not to vote, not at all. Democracy, as defined in the Council of Europe, is to respect legality, to respect the division of powers, to the respect of human rights, and also participation of people. But not only the participation of people. And after the Second World War, states were very aware of the problem of linking democracy only to vote. Remember that Hitler was elected by people. So that's why they, when in the treaty founding the Council of Europe, there is in the preamble, there is a definition of democracy, and says clearly that democracy is based on the legality principle. No one is over the law. And what has happened in Catalonia, as a Catalan, I say probably you don't know about the 6th and 7th of September of last year. It was really, really horrible as a Catalan to see how my participation rights were really violated by the half part of the parliament. They care about the interpretation of facts. And then, very important, a declaration of independence doesn't build a state, even if there are recognitions. The effectivity principle is very important. What's that? What does it mean, effectivity? Effectivity means to have the control of the legally, executive, and judicial powers in a territory over the people. When a secessionist movement acquires this effectivity, they become a state, even if there are not recognitions. Here, even if this secessionist movement they don't have a right according to international law, in this point, another international law norms enters into the role, the norm of effectivity. So even if there is a declaration of independence, if there is not effectivity and other states recognize Catalonia, the other states were violating the rights of Spain to its territorial integrity. Sorry. So this is very important. And non-intervention is yes, of course, non-intervention. And what's the political solution to the Catalan problem? Well, reconciliation and dialogue and human rights respect inside the Catalan society. Probably you don't know, but the Catalan society is devised. It's a social conflict. People who doesn't speak to other people. In the village, you can go to the village and all the public sphere is all with yellow, the trees. Really, this is the deepest problem we have, the social conflict inside Catalonia and the human rights violations, discriminations from the hegemony of the government, of the Catalan government, which is an hegemony. They control the television, they control the newspapers, they control, and they are discriminations against people who they speak Spanish as a mother tongue, or they put the answers in the shops in Spanish. People is suffering. So, which is the political solution? Reconciliation, dialogue inside Catalonia, of course, also between the nationalism and Spain, but previously, dialogue inside Catalonia and feel together, not to push this extremist nationalism, which includes supremacism, and somehow, even if it's very hard maybe to tell this here, but somehow this is.
Thank you very much, Professor. In the interest of Professor Blanchot.
Yes, just the last word. There is somehow against Spanish people, and this is xenophobia. Thank you.
Thank you very much, Professor Blanchot.
Okay, thank you.
4 minutes.
Yeah, 5 quick ideas. First of all, according to my colleague Agnieszka, the referendum of 1st October 2017 was contrary to international norms for democratic elections, norms enshrined by the Copenhagen document 1990 and Code of Good Practice of Venice Commission. So the referendum was illegal from the procedure and also from the basis. Secondly, what we are living in Spain and Catalonia is a distortion of the concept, the right to self-determination. It's very easy to convince the people saying, okay, we only want to vote. We only want to vote. Who is going to say the contrary? No, I don't want to vote because the vote belongs to all the Spaniards. It's easy to convince people in order to distort this concept. But international law says what we have been speaking in these papers. Third point, effectivity. Of course, effectivity is a requirement to gain a statehood. But in order to introduce or to include some doubts about the concept of effectivity. In the case of Kosovo, the authorities of Pristina didn't manage effectively the whole country when they gained independence. And they were supported by international community, United States and international organization. Effectivity, I think, is a relaxed sometimes. And also in Spain, with the decentralization of the regions and the autonomous communities, they have powers and competence in order to gain some kind of effectivity or some similar to effectivity. Fourth question, and very important, a binding referendum in Catalonia will mean a break of the popular sovereignty of all Spaniards. Because if they only vote about a part of my country, they are preventing me from voting for about a part of my country. And in the Spanish constitution, the sovereignty is of all Spaniards, belong to all Spaniards. So I think this is an important question to take into account. And finally, solution. In my opinion, there are two possibilities. First of all, a consultative referendum, to know what is exactly the number, the support in Catalonia about the possibility to become independent. In my opinion, would be a good idea, because in Catalonia, people want to vote. And vote, but consultative. It's nothing to do, it's not risky, in my opinion. And secondly, also in my humble opinion, and taking into account that there are very different cases, the case of Quebec is very interesting for Spain. It's very interesting for Spain. Why? Because I think that what the Supreme Court of Canada stated in the famous judgment, and I'm going to say literally, if in a referendum a clear majority answer affirmatively to a clear question in favor of the independence, the result would impose an obligation to the federal government to negotiate constitutional changes, including the possibility of a secession, although not necessarily the solution had to be that of secession. It's very interesting, this point of view, because the solution is not only the secession. And in Catalonia, the society is clearly divided, 50-50, 48-52. So I think it's nothing to do, it's not possible, the secession, with only the 50% of support in Catalonia. So, but it's interesting because at least the government will know that some constitutional changes have to be done in order to adequate the Constitution of 1978 to 2019. But after saying this, I can just say that we need better politicians in both sides, of course, in both sides, to achieve this political arrangement. Thank you.
Thank you very much. It's very important, I would say, we are not talking about the human rights, about the right to work, sorry, but also the right to take a rest. So ask, I would say, and make a comment privately during the dinner. Sorry, sir. Officially, my competence is here, has gone.
One comment. Sorry. Thank you very much. It's very interesting. But to my mind, is two comments very interesting. First of all, that it's impossible to have decision inside of the law, because it is outside of the concrete law. It's near to politology of the law, because it's very connections, combination of politics science, and lawyers. To my mind, is as human rights as the situation inside this. And secondary, about history and analogy, because in our experience of Soviet Union declining, there was referendum for, first of all, referendum for the unity of Soviet Union, and 75% vote for that must be one country. But through some some months, it was dissolved. You must understand. And also very maybe useful for everybody, some experience, it's results of our research. It's published paper. Very interesting. Where is Estonia, where there is big part of Russians, and leader of this city council decided to organize a referendum for economical sovereignty of this East Estonia. What they do, leaders of Estonia state, not to have some pressure or other, they invite him to have a little expedition to Moldavia to see what it was with independence of Prидnestrovia, Transylvania, whereas near to 1,000 people was killed. And after this, when he returned to his Estonian city, he said to the leaders, we organize referendum, but without concrete results. Because he sees that some other guys from Omon of Riga or other try to go from the Russia to support this. And it was very interesting that he go specially and collaborate with Putin as a deputy of Sobchak, that to stop this part Kazakhs and other go to Estonia. And referendum was exist, but no results. It was some additionally decision of Estonian leaders and was more peaceful. But what is interesting that Moldova guys looking for these results and use this approach with Gagauzia, other very famous. It was also peaceful. The title of my paper, where is elites can to have lessons from the mistake of others. Maybe it would be useful also for which I absolutely agree that it's necessary some negotiations. But from the point of view, the law is absent because it's other situations. Thank you very much. It was absolutely present session.